Hello everyone, and welcome back to Legal Insights, your go-to channel for understanding the law across the US, UK, Australia, and Canada. Today, we're tackling a topic that can feel incredibly daunting: eviction. If you've ever faced the possibility of losing your home, you know the stress involved. But here's a crucial truth many tenants overlook: landlords cannot just throw you out. The law gives you powerful protections. Understanding these rights is your first and best defense against illegal evictions and unfair treatment. We're going to break down exactly what those protections are, from proper notice to getting your security deposit back, and how you can assert them effectively. Stay tuned, because empowering yourself with this knowledge is key to navigating what can be a very challenging time. The foundation of any legal eviction process, no matter where you are in the US, UK, Australia, or Canada, begins with proper notice. This isn't just a courtesy, it's a fundamental legal requirement. A landlord cannot simply tell you to leave tomorrow. The notice must be in writing, specify the reason for eviction, and give you a legally mandated amount of time to respond or remedy the issue. For instance, in the United States, notice periods vary widely by state and city, often ranging from 3 to 30 days for non-payment of rent, or even longer for lease violations that can be cured. Some states, like California, require a 3-day notice to pay rent or quit, while others, like New York, might require a 14-day notice. For month-to-month tenancies without cause, a 30 or 60-day notice is common. In the UK, landlords typically need to issue either a Section 8 notice for breaches of tenancy agreement, or a Section 21 notice for no-fault evictions, particularly if you're on an assured shorthold tenancy. These notices have specific forms and minimum timescales, often 2 or more months for a Section 21 notice. If a landlord issues an invalid notice, their claim for possession will fail in court. Australia's states and territories also have their own residential tenancies acts, dictating notice periods. For example, in New South Wales, a landlord must provide 14 days notice for unpaid rent or a serious breach, or 90 days notice for no-grounds evictions after a fixed term ends. Similarly, in Canada, each province has its own Residential Tenancies Act. In Ontario, for instance, a landlord must use specific forms like an N4 notice for non-payment of rent, giving at least 14 days notice, or an N12 notice for landlord's own use, requiring 60 days notice. The common thread here is that the notice must be correctly served and adhere to specific legal timeframes and content requirements. If your landlord fails to provide a proper written notice, it's a strong defense against any eviction action. Always keep a copy of any notice you receive and note the date you received it. Receiving an eviction notice is not the end of the road. It's the beginning of a formal legal process. And crucially, you have the right to contest that eviction in court or before a tribunal. An eviction is not final until a judge or tribunal member issues an order for possession. Your landlord cannot legally remove you from the property without this order. In the US, after the notice period expires, the landlord must file an unlawful detainer lawsuit. You will be served with a summons and complaint, and you'll have a limited time to respond, typically 5 to 10 days. This is your opportunity to present your side of the story. Common defenses include: the landlord failed to provide proper notice, the rent was actually paid, the landlord failed to make necessary repairs, breaching the implied warranty of habitability, or the eviction is discriminatory or retaliatory. In the UK, if you don't leave after a valid notice, the landlord must apply to the court for a possession order. You'll receive court papers and have a chance to defend yourself at a hearing. Legal aid might be available. and housing charities can offer invaluable support. Australian tenants will generally have their cases heard by a civil and administrative tribunal, such as NCAT in NSW or VCAT in Victoria. These tribunals are designed to be less formal than courts but still require you to present evidence and arguments. You can argue against the grounds for eviction or seek an extension of time. In Canada, provincial landlord and tenant boards, like the LTB in Ontario, are the primary forums. These boards conduct hearings where both parties present their case. You can challenge the landlord's claims, provide evidence of rent payment, or argue that the eviction is unjust. The critical takeaway here is: show up. If you don't respond to the lawsuit or appear in court, a default judgment will likely be entered against you, and you will lose your right to challenge the eviction. Gather all your evidence: rent receipts, communication with your landlord, photos of disrepair,